Um, Again, it is with great pleasure that we officially give the floor to our first panel in Beijing, our first BAC. Good morning. This is for the recording purposes. It is with great pleasure that we give the floor to our first panel, and it is for me a great honor to be introducing the panel on the developments in Chinese law and the new developments in Chinese arbitration. And when we originally conceived this panel, we thought that it would be very good to have a a panel with experts on Chinese arbitration, knowing that there have been lately many developments in the law of arbitration in China, and what better topic to start the World Arbitration Update from Beijing for the rest of the world, but to start concerning the study and analysis of the Chinese arbitration law. So it is with great pleasure that I am introducing Miss Helen Shi. Miss Helen Shi is a partner and at Fund that law, and she has a practice that focuses on dispute resolution, including, of course, international commercial arbitration and litigation. She serves as vice president of the ICC Court of Arbitration and co-chair of the IBA Asia Pacific Arbitration, amongst many things. And I could go on and on, but I know that Ms. Shi would not appreciate it. So it is with great honor that I give the floor to Ms. Shi. Welcome.
Good morning, Madam Jiang, not here, and founders of WAU, Mr. Ian Lind, and also Mr. Jose Antonio Rivas, my dear panel speakers and distinguished guests, good morning. Let me first introduce our experienced panel speakers. On my left, Miss Zhao Fang. Miss Zhao is the partner of Huizhong Partners, and Mr. Wang Zhengzhi. Mr. Wang is a partner of the Global Law Lawyers. Mr. Wang primarily practiced in the field of IP protection and commercialization, and also serves as an arbitrator for several institutions such as BAC, CTAC, SIAC, SHIAC. Since 2023, he has been the chief editor of the China International IP Arbitration Annual Report for consecutively 2 years. Professor Lu Song is a professor at China Foreign Affairs University and also a very experienced independent arbitrator. Mr. Sheila is a partner of Clifford Chance and managed partner of Clifford Chance Beijing and the Shanghai offices. Ms. Ye Wei Na is an international partner of Herb Smith's Freshfields Covey offer. As the founders of WAU, Jose just introduced, one of the functions of the WAU is to provide updated information on international arbitration to the arbitration community. This is the reason I believe that why the first panel discussion of this 2 days event is for discussing the update and the new development of arbitration in China. In this session, the experienced arbitration practitioners will introduce the update on legislation, legislative regulations, institutional rules in relation to Chinese arbitration, and the update on the arbitration practice in China in relation to the IP-related disputes. Let's first invite Miss Zhao Fang for giving her talk on the amendments of the civil procedure law and how it affects on the nationality of the arbitration award and the enforcement of the foreign arbitration award in China. Ms. Zhao, please.
Yes, good morning. Good morning, everyone. It's my honor to be here. So today I'm going to give you an update regarding the new amendment on the civil procedure law, which will have a significant impact on the arbitration practice in this country. So two amendments are relevant to today's discussion. One is a new criteria for determining the nationality of arbitral awards, and the other is relevant to how to file a case before a PRC court for enforcing foreign arbitral award. So on January the 1st, 2024, the new civil procedure law came into effect, introduced two amendments that are relevant to arbitration. Specifically, Article 297 and 304 stipulate that the nationality of any arbitral award will be decided according to the place where it is made. And let's look at the old laws. So under the old CPL of 2021, the nationality of an arbitral award is decided according to the place of an arbitration institution which renders this arbitral award. So we all know that an arbitration institution may operate different branches or carry out arbitration activities in different seats. So sometimes this will cause confusion especially in terms of the enforcement, where the court needs to decide the applicable law to review the arbitral award. So under the old laws, the approach is actually somehow inconsistent with Article 1 of the New York Convention, because the New York Convention mandates the enforcement according to the territory where the award is made. Now, let's explore a little bit regarding the historical evolution of the case law to understand the genesis of the new amendment. So 20 years ago, in Hualong case, an ICC award was enforced as a French award, but the ICC award actually was made in the United States. 1 year later, in Tianli case, an ICC award made in Hong Kong was also enforced as a French award rather than a Hong Kong award. So during those times, actually the Chinese court rendered varying decisions. So for instance, in 2006, the Supreme People's Court decided in Zublin case that an ICC arbitration agreement stipulating arbitration in Shanghai to be null and void. This is because even until now, the PRC arbitration law still does not stipulate that a foreign arbitration institution can be registered and operate in China. This is something that the new arbitration law will try to resolve. And 2 years later, however, the Ningbo court decided in another case that an ICC award rendered in Beijing can be enforced as a non-domestic award in China, according to the New York Convention. So the Ningbo Court's decision was welcomed by the arbitration institution and by the arbitration community, but it raised a legal question. Because when adopting the New York Convention, China specifically made a reservation under Article 1 of the New York Convention. That is, China will only enforce the foreign arbitral award made outside of China. China will not enforce the non-domestic award according to the New York Convention. Therefore, the Ningbo Court's decision was inconsistent with the reservation of China as per the convention. The turning point of this discourse appeared in 2013 in two landmark cases, that is a Long Lai case and Ningbo Beilun case. The Supreme People's Court affirmed the validity of two ICC arbitration agreements stipulating ICC arbitration respectively in Beijing and Shanghai. So these remarkable cases marked a shift of the legal landscape. So after the Ningbo case in 2016, ENID case saw an CTAC award be enforced as a Hong Kong award. Then in 2020 came the very famous Brentwood case. In Brentwood case, the Guangzhou court was asked to enforce an ICC award rendered in Guangzhou. So with the endorsement of the Supreme People's Court, Guangzhou court decided that this award was a Chinese award and should be enforced according to the local laws. In no doubt, Brentwood is a landmark case because this is the first time that a PRC court enforced a non-domestic award as a Chinese award, even without any clear legal basis under the Chinese law. Now we have the new amendment of the CPL, which reflected the judicial development observed in Brentwood case. So this amendment will have a significant impact on the future of the arbitration practice. So first of all, this amendment aligns with Article 1 of the New York Convention. Previously, any non-domestic arbitral award will not have any legal background to be enforced in China, either under the New York Convention or under the local law. But now the new amendment provides a legal ground for the enforcement of non-domestic award made by foreign arbitration institution in China. And also, this amendment extends the enforceability not only to the non-domestic award, but also to any ad hoc arbitral award made in China. So this amendment demonstrates a pro-arbitration stance without violating China's reservation under the New York Convention. Now, the second amendment. The second amendment is regarding how to file a case before a Chinese court for enforcement of foreign arbitral award. And under the old law, there are only two connections when you want to enforce a foreign arbitral award in China. Either the respondent's domicile shall be in China, or the respondent shall have assets in China. But question raised and criticism came regarding those provisions in practice. So for instance, if an arbitral award only contains declaratory rulings such as confirmation of the respondent's breach of contract, then question raised regarding whether the applicant will be able to recognize and enforce such foreign arbitral award in China if the respondent is neither resided or nor have any assets in China. There are also other concerns especially whether the applicants should be deprived of the opportunity to recognize or enforce their arbitral award if they do not have enough resources to locate the respondent's assets. Now we see the new amendment addressed both criticism in practice. They added 2 more new connections for enforcing foreign arbitral award. One is that if the applicant's domicile is in China, then the arbitral award can be enforced in China. Or if the applicant cannot find any above connections, then appropriate connections with the dispute involving the award might be established as the last resort. So the new amendment addressed the issues in the practice and demonstrated a more flexible and open stance for enforcing arbitral award, and therefore is a very welcome amendment. That ends my presentation today. Thank you very much.
Thank you, Ms. Zhao, for giving us the update on the amendment of the CPL. I would like to ask whether our panel speakers want to comment on this new amendment. Maybe Professor Lu?
Thank you, Madam Chairwoman. Good morning, everyone. I feel privileged to be invited to this panel and talk about some of the new developments of the Chinese law in the sphere of arbitration. In respect of Ms. Zhao Fang's presentation, I would like to draw your attention to 2 points. Before that, I would like to give a special thanks to the Chinese Supreme People's Court, because their judicial practice set up the foundation for this new amendment of the Chinese Civil Procedure Law. 2 issues. Number 1, as you know, that the Chinese Arbitration Law, Article 16, has a unique requirement, require that the validity of an arbitration clause shall include a designation of an arbitration commission. So what does that mean, an arbitration commission? So there is some dispute. Someone argued that this arbitration commission only refers to the Chinese Arbitration Commission, which registered with the Chinese authorities. However, this is a wrong concept. It's a wrong understanding. The Supreme Court later, as Ms. Zhao Fang mentioned in those cases, the ICC is qualified as an arbitration commission under Chinese Arbitration Law Article 16. So any arbitral institution in the world will qualify now under Chinese Arbitration Law, Article 16, with the support of Supreme People's Court decision. So this is first point. The second point is, as Ms. Chow mentioned, that the concept of seat of arbitration was introduced and accepted over the past maybe 5 to 10 years by the Supreme Court as a connecting factor to determine the nationality of an arbitral award. So the previous Chinese Civil Procedure Law says that foreign arbitral institution, the award of foreign arbitral institution will be recognized in force in China. So the Chinese court determined that the nationality of an arbitral award will be determined previously by the location of a foreign arbitral institution. Now it changed. It changed that use the seat of arbitration or place of arbitration as the connecting factor to determine the nationality of the award. That's all for my comments. Thank you.
Thank you, Professor Lu. Mr. Wong, do you have any comments on this? Okay, good. Professor Lu's comments. Yeah. Let's move to the next topic. Many of you may know, and also as Professor Lu just introduced, arbitration law, Article 16, require the designation of arbitration commission in the arbitration clause to make this clause to be a valid one. So that means the Chinese law doesn't allow any ad hoc arbitration. All the arbitration must be administrated by a arbitration institution. Do we have any update? Maybe some local regulations has allowed, like make a step further, allowing ad hoc arbitration in certain specific area. Ms. Ye Wei Na will bring this topic to us. Ms. Ye, please. Sorry?
Thank you very much, Helen. Very happy to be here today and to see World Arbitration update to come to China. And I'm very glad that the first session this morning is on new updates on Chinese arbitration law. And as you have already sort of had a flavor from the presentation made by Miss Chow and also the comments from Professor Lu and Helen, there are certain unique features of arbitration in China, and that to a large extent is perhaps because that our arbitration law is rather dated, and there are certain rules or provisions which are not entirely in line with international sort of practices, and that includes what Ms. Zhao mentioned. For example, you know, the concept of seat under PRC arbitration law wasn't fully recognized, and under PRC arbitration law, it uses a concept such as the location of arbitration commission as a replacement of the seat of arbitration, and that's why. And another feature is that, as Helen and Professor Lu already mentioned, we do not allow ad hoc arbitration, as you could see from this slide, because, sorry, I think there's a typo there. Article 16 says that a valid arbitration agreement must specify an arbitral institution, and therefore ad hoc arbitration in China is not permitted. And that is to say that ad hoc arbitration seated in China is not permitted. But as you could see from the last bullet point here, it indeed is admitted, it is recognized that ad hoc arbitration could be seated elsewhere in other jurisdictions, and awards rendered in those ad hoc arbitrations could be enforced in China. But coming back to our topic today, ad hoc arbitration seated in mainland China is not permitted under the existing PRC arbitration law. But in reality, commercial parties that may have needs to have ad hoc arbitration. There are a few examples, as some of you may know. For example, there are reporting by Beijing Arbitration Commission saying that they have offered hearing facilities to ad hoc arbitrations conducted. Well, I mean, in that case, the seat was Hong Kong, and the parties agree. I think the agreement was also governed by Hong Kong law, and it was a valid ad hoc arbitration agreement, but it was between Chinese parties. The hearing was conducted at the Beijing Arbitration Commission. And those cases demonstrate that Chinese commercial parties sometimes do use ad hoc arbitration in their business operations. And it is the fact that our PRC arbitration law does not allow, is not consistent with that commercial needs. And therefore, in past 10 years, more than 10 years, you see various sort of groups of people, organizations try to liberate that prohibition or rule in China. And you would see that obviously the first step was taken by the Chinese judiciaries, particularly our Supreme People's Court. And back in 2017, in the context of free trade zones, where our government allows more liberated rules, the Chinese Supreme People's Court issued an opinion to say that enterprises incorporated in free trade zones may submit their disputes to ad hoc arbitration. The exact wording used in the opinions are that it did not say, expressly ad hoc arbitration, but it says that parties or enterprises incorporated in free trade zones may submit their disputes to arbitration at a certain location pursuant to certain arbitral rules and handled by certain personnel or individuals. And that by, most of the sort of people in arbitration community as a permission to ad hoc arbitration, but that is restricted to disputes between enterprises incorporated in free trade zones. And that message was repeated in an SPC opinion on a specific free trade zone, Shanghai Lingang Free Trade Zone, issued in 2017. So that was the first step. But as many people have pointed out, these are sort of a general provision issued by SPC. It doesn't set out detailed rules as to how ad hoc arbitration could be implemented in practice, who would be the appointing authority, where would the parties find their arbitrators, and etc. And hence, you could see that the second step is that certain local legislatures and certain local judicial sort of administrations, they also take a further step to set out more detailed rules on that. And I'm based in Shanghai, so I'm bringing the Shanghai rules. The Shanghai legislatures at the end of 2023, last year, issued a municipal regulation promotion development of International Commercial Arbitration Center. And in Article 20 of that regulation, the Shanghai legislature specifically said that it will explore mechanisms for ad hoc arbitration of foreign-related commercial and maritime disputes in Shanghai. When it says in Shanghai, it means seated in Shanghai. So that is the general sort of local legislation published last year in Shanghai. And further to that, just a month ago, in March 20, a couple of months ago, March 20, sorry, I think there's a typo. It should be 2024 instead of 14. The Shanghai Bureau of Justice published a set of measures it hasn't yet become effective, but it's out for comment. It says that in Shanghai, certain disputes could be submitted to ad hoc arbitration. And there it sets out, in the first sub-bullet points there, you could see that it set out certain parameters for ad hoc arbitration to apply. So first of all, it applies to foreign-related maritime and commercial disputes. And so it doesn't apply to sort of purely domestic. For those who are familiar with PRC arbitration law, you would know that we make a distinction between domestic dispute and foreign-related dispute. And this measure would apply to foreign-related maritime and commercial disputes. And secondly, there are sort of scope so by reference to parties incorporation, where they incorporate. So it would only apply to enterprises incorporated in Shanghai free trade zones, i.e. both parties are incorporated in Shanghai free trade zones, or it could be between a enterprise incorporated in Shanghai Pudong district and another party. It doesn't specify which party that could be. It could be a party incorporated in other jurisdictions or in other parts of China. And a third category is that, it would be between enterprises incorporated in Shanghai or other enterprises incorporated in Shanghai. So we could see there that on the one hand, these measures sort of limit the scope of application to foreign-related maritime commercial dispute, but on the other hand, it tried to sort of expand the scope of application in terms of, the party's identity. There you could see that it does not only apply to sort of parties incorporated in free trade zones. It could apply to parties incorporated in the entire of Shanghai, or it could apply to, disputes between a party incorporated in Pudong and another party, and that other party could be incorporated in anywhere else. And so I think that's quite interesting. And what the measures published by Shanghai Bureau of Justice tries to achieve is further than that. It also provided certain rules on how parties could appoint arbitrator and how ad hoc arbitration could be conducted in Shanghai, including, who the appointing authorities could be, whether the tribunal could hire a tribunal secretary, and etc. So you could see that the measures encourage, or actually it says that it will support the Shanghai Arbitration Association, which is a private association among the arbitration community in Shanghai. It supports the Shanghai arbitration community to publish its recommended list of arbitrators for parties to choose from in ad hoc arbitrations. It also support the association to publish a set of rules to be used in ad hoc arbitrations in Shanghai. That is, despite the party's autonomy to appoint anyone else who are qualified under PRC arbitration law or adopt any other arbitral rules, it also encouraged local arbitral institutions to provide necessary services, for example, appointing services, providing sort of treasury services or case management or a case filing of management of case file services to parties in such ad hoc arbitrations. And therefore, that is the local rules there. Following that, there are some sort of institutional guidelines published as well. As you see, Shanghai International Arbitration Center has followed up and published a series of guidelines in terms of, how it could act as an appointing authority and provide other services to parties in ad hoc arbitrations. So coming back to what we discussed at the beginning of the presentation, there are restrictions under PRC arbitration law, despite the efforts of the Chinese judiciaries as well as local legislatures in terms of trying to liberalize the rules or restrictions in China. I think the PRC, the biggest hurdle is still that the PRC arbitration law, as the main law governing arbitration seated in China, still does not allow ad hoc arbitration at this stage. And therefore, you would see that, recent released draft revised arbitration law, there are rules trying to sort of modernize or innovate the area of ad hoc arbitrations in China. There are proposed rules for ad hoc arbitration in relation to foreign-related commercial disputes. So you may see in the upcoming new PRC arbitration law that ad hoc arbitration is permitted for foreign-related commercial disputes, and there will be certain other rules which will operate in these ad hoc arbitrations. For example, the future, the upcoming PRC arbitration law might provide that, in cases that parties couldn't appoint their arbitrators, they could apply to local courts to designate an arbitral institution as the appointing authority in that case, and all various rules to support ad hoc arbitration in the PRC. There will be submitted, the revised PRC arbitration law would be submitted to the Standing Committee of the National People's Congress for an initial view this year, and so stay tuned there. So that concludes my presentation, and that's the development on ad hoc arbitration.
Thank you, Ms. Ye, for bringing this update to us. Hopefully, the new revision of the arbitration, PRC arbitration law would allow ad hoc arbitration in China. But most of the panel speakers and also the audiences in this room are practitioners, arbitration practitioners in China. So I'm wondering, I know, from academics, this is ad hoc arbitration is welcoming and promoting the PRC law to allow ad hoc arbitration, but I'm not sure whether, the practitioners are welcoming such change or believe this change is practical or realistic. So I would like to hear the view from maybe Zhao Fang or Shilei, maybe Shilei or.
Okay. All right. Thank you, Helen. I definitely agree that the development shared by Ms. Ye is a positive development from the policymaker perspective. To lift the restrictions and to respect more party autonomy, which is generally a kind of a good thing for international arbitration. But as Helen has asked the right question, what that means for council, but I guess more importantly, what that means for end users, for the parties, for the companies. Would the companies actually thinking, now we have this ad hoc arbitration, I will move from choosing institutional arbitration towards choosing ad hoc arbitration? I think quick observation is that even in jurisdictions where which has recognized ad hoc arbitration for a long time, or even have more tradition in ad hoc arbitration, the general trend seems to be that more and more parties will favor institutional arbitration over ad hoc arbitration. Apparently in textbooks, there will be discussions about unique advantages of ad hoc arbitration, like less fees, but is that really an advantage in nowadays, especially when the parties are not really collaborative, they're trying to create issues for each other? Then in that situation, whether intervention or management by the institution will actually reduce the cost and time. I think probably more cost saving go for institutional arbitration than ad hoc arbitration. So my own guess is that, of course, this is also based on my discussion with clients and end users. Other than in certain areas where there's so strong tradition of ad hoc arbitration, such as maritime or commodity trading, other than that, almost all of the clients say, I don't really care, whatever mechanism which will allow me to resolve the dispute in the most cost and time efficient manner will be the thing you choose for me. So I guess that will be the answer also from the practitioner's perspective, because when we advise our client, we probably cannot say to them that you should choose this because this is generally good from the policy perspective, but we need to and have to look into what really matters and works in their specific contracts and in their specific case.
Thank you. Yes. Yes. Yes.
可以吗？现在可以吗？ Okay, thank you. So, yes, I guess that both Sheila and Weina both introduced the current development of the ad hoc arbitration in China. It is a positive sign, but I guess that our distinguished guests will have a question, because when I drafted last year's annual review on the commercial dispute resolution for BAC, we actually got the data that last year, the 279 arbitration institutions administered more than 600,000 cases in China. So actually in China, the institutional arbitration is very prosperous. So the question raised as to why do we need ad hoc arbitration now in China? So probably I have my own guess, because last year when also Beijing Arbitration Commission was holding the APRAG meeting, and the representative from the Ministry of Justice announced that it is China's intention to build up an international arbitration dispute resolution center in the future. So as the international arbitration center, it probably will be very inconvenient not to have ad hoc arbitration, as a whole, as one of the methods in the arbitration practice. And Weina also Sheila demonstrated many, positive development, but I will comment on the difficulty actually we will encounter in developing ad hoc arbitration in China, because Huizhong has been invited by the Judicial Bureau of Shanghai to give their practitioners' comments regarding the draft regulation on promotion of the ad hoc arbitration. I will summarize some of the difficulties we see in the development. So first of all, we all know that ad hoc arbitration covers especially those special industries like Sheila mentioned, the maritime industry and commodity trading and also investment arbitration. So the participants of ad hoc arbitration are the sophisticated players. They actually do not need, much assistance from the institution. They will tailor-made their own proceeding. So for ad hoc arbitration, it is essential to have the judicial support to resolve some difficulty or deadlock during the ad hoc arbitration. For instance, the constitution of arbitral tribunal, or recusation or replacement of arbitral tribunal, or judicial support for interim measures, something like that. But these issues actually might not be easily resolved only by local legislation, because the court's power is granted by the law. So without the amendment of civil procedure law or without the amendment of the arbitration law, it is somehow a little bit difficult for the court to give support to the ad hoc arbitration. For instance, recusation of the tribunal member. If there is any irregularity, then who has the power to recuse the arbitrator? Will the appointing institution have the power? It really depends. And if the court needs to hear the case and try to recuse the arbitrator, who gives them the power? It should be the legislative power given to the court, but rather than by any local regulation. So this is something we believe that will be better resolved by the national legislation. And the same issue is regarding the interim measures granted by the court. Now in Shanghai, the court can grant some kind of interim support in Shanghai, but that because we are very big country and ad hoc arbitration may be relevant to assets out of Shanghai, then how should the court deal with those issues? So despite we have a very positive development, that's for sure, but we also have a long way to go. That's my comment. Thank you.
Thank you, Sheila and Zhao Fang, for your wonderful comments. As Zhao Fang also mentioned in her PPT, and also Professor Lu mentioned, thanks to the SPC for all those years, trying to bring inventive measures to resolve practical issues in the Chinese arbitration, Chinese arbitration practice. So I believe what the arbitration institution had done, and also the local legislator had done, are sort of inventive measures, will have certain influence power to the legislation, therefore allowing the legislation to pass the new arbitration law or CPL, civil procedure law, simply allowing ad hoc arbitration, giving more options to the parties to choose. Thank you for your comments on ad hoc arbitration. I'm very enlightened by Weina's presentation and the comments from Zhao Fang and Sheila. Thank you very much. And now let's move to the next topic for the evidentiary guidelines and the practices using CTAC as a sort of really recently amended rules on arbitrary guidelines as a hook. Mr. Sheila, thank you.
Thank you, Helen. Two things to note before I start. First of all, as Helen has just mentioned, I will comment or use the recent amendment of the CTAC rules as a hook. Apparently today we're in the venue of BAC, but I'm very grateful that our friends in BAC doesn't prevent me from commenting on another institution's rules, because that apparently have general relevance to the practice in China. The second part is that although we're talking about the amendment of the CTAC rules, there are a lot of amendments in this round, but we just pick up a very small part of that, largely because that's something which we think will be of relevance to today's topic or the general theme of WAU, which is to bridge the differences of legal cultures and legal traditions. And evidence is apparently one area which we do see quite a lot of difference between different legal traditions, common law and civil law, and China practice and overseas practice. So with that note, I will, before I actually go into the amendment of the CTAC rules, I would like to say a few words about the traditional features of evidentiary rules and practices in Chinese arbitration. First of all, for the benefits of our friends coming from other jurisdictions, both in this room and also online. And also that's going to be the context for our discussion about the amendments and what the future will look like. So several key features of the arbitration evidence practice in Chinese arbitration. First of all, the practice is strongly influenced by the evidence rules and practice in Chinese court proceedings. Although as a matter of law or regulations, there's no strict requirement that the arbitral tribunal have to follow the civil procedure law or the judicial interpretations for the evidence rules. But in practice, because most practitioners both do litigation and arbitration, and also there are many arbitrators who are formal judges, so they're still quite strongly influenced by the court practices. And relevant on that basis, there are several key features of the evidence rules. First of all, there's a heavy reliance on documentary evidence. So basically, for most of the things you try to prove and convince the court or the tribunal, you have to have documentary evidence to present your case. Of course, documentary evidence will be understood expensively to cover also like electronic or other form of like records. And the other side of the coin is that there's very limited use or reliance of witness statements, and even less for oral testimony by the witnesses. Although, as a matter of law, again, the law permits and allows the parties to produce witness statements and allow witness to give evidence or testimony in the hearings, but in practice, it doesn't really happen a lot. In my experiences, I would say probably less than 10% or 5% of the cases, you will see one or two witnesses just like give very discrete evidence on certain issues, which is important but not reflected in the documentary evidence. And of course, there's no, very uncommon, unpopular to have the common law style of cross-examination of witness in hearings. So that also means that hearings usually much shorter than we will see in arbitration in other parts of the world, Hong Kong, Singapore, US, or UK. And also similarly, for expert evidence, although from time to time there may be tribunal-appointed experts or tribunal consult with experts on certain particular issues, but it's very unpopular or uncommon for a party to adduce their own party-appointed experts or adduce party-appointed expert evidence. Last but not least, also relevant to the whole kind of legal culture, legal tradition thing, there's very limited, I would say probably almost no document production or discovery. So basically you only use your own evidence, your own pocket. If you try to say something on the other party's hand, and if you are unable to get that from the other party, then you probably wouldn't be able to rely on that. Again, as a matter of law, the parties can always ask the tribunal or court to say, actually, the tribunal court, you should direct the other party to produce this particular evidence. But in reality, most of the tribunals wouldn't entertain that request most of the time. And even if they do, it's much, much less and much narrower than the document production or discovery process in overseas arbitration or common law litigation. Sometimes it's just like one or two documents. So with that context, we look into how what's kind of the recent trends for the parties or councils who try to bring in the common law features or overseas arbitration features in evidence into the Chinese arbitration. One thing that has been done from time to time is to, on a case-by-case basis, to adopt international guidelines. Of course, everyone in this room and online will be very familiar with the IBA rules on taking of evidence in international arbitration, which is sort of a hybrid or a combination of the common law and civil law traditions. So there will be some level of witness testimony, cross-examination, discovery, but not as expensive as the US court version. And also, there will be the other version of the kind of a common evidence rules, which is PRAC rules on the efficient conduct of proceedings in international arbitration. Although I would say that in my experiences, I have never seen that really being adopted in the arbitration in this part of the world. But on IBA rules, just like two comments. One is that if you have the tribunal, which is very common law favored, or like, for example, is a common law lawyer or common law arbitrator, or if you have the counsel or parties coming from the common law jurisdiction, they may be able to agree in the PO or PO equivalent to adopt IBA rules as a guideline. So, but that doesn't always happen, especially when the parties cannot agree or when the tribunal is so diversified and you don't have a fully international tribunal. The other scenario where we see this happen is where the parties agree in their arbitration agreement to adopt IBA rules as the guideline for the evidence rules. We do see that in one of the cases we handled years ago in a CTAC arbitration where the substantive governing law is Hong Kong law. And in the arbitration agreement, there's a provision that saying that the tribunal should follow the IBA rules, so that in that case, although it's a Chinese onshore case, we do have some level, and actually quite extensive level of discovery, and we do have the very common law style of hearing, so 5 days cross-examination of experts and witnesses. Those are the kind of the context, and we come to the real core of the development in China's side. So in 2015, CTAC for the first time published its own guidelines on the on evidence, and it, to a large extent, follow what has been provided under the IBA guidelines. Although, of course, also combine some of the Chinese arbitration features, but at the very least, it provides some of the mechanisms which is more commonly seen in the common law jurisdiction. So there's some provision on discovery, there's some provision on witness statements, and some provision on party-appointed arbitrators. But one interesting thing of this rule is that it says that it only applies in cases where the parties agree to adopt the CTAC guidelines on evidence. Although I don't have statistics, by my own experience is that parties can hardly agree on anything after their dispute arises. So at least from the kind of discussions with CTAC or other practitioners we have, is that with this rule guideline published for nearly 9 years, it has not been very often adopted in real practice, because the scope of application is so limited, and that unless both parties are coming from kind of our international parties and they are friendly to each other, they're very collaborative, then they simply say, oh, it's not something I'm familiar with. I don't want to have discovery. I just want to do what I'm familiar with. That probably the reason prompt the recent amendment in the CTAC rules, which is on Article 41.4, which provides that unless otherwise agreed by the parties, the arbitral tribunal may decide to apply in whole or part of the CTAC guidelines on evidence to hear the case. However, the guidelines of evidence do not constitute an integral part of these rules. There are two interesting parts of these rules. First of all, it changed the previous mechanism, which is effectively an opt-in mechanism to an opt-out mechanism. Of course, it still leaves the discretion to the tribunal, so it doesn't really say the tribunal have to apply those rules, but it doesn't, it's no longer conditional, fully conditional on the parties' agreement, which is rarely happen. So at the very least, in cases where the tribunal is familiar with the more international practice, or be willing or thinking that the CTAC guidelines on evidence is suitable for the particular case, even without the parties' consent, they can resort to this new provision and apply the rules. And the second part of the interesting interesting provision is that it says that the guideline doesn't constitute part of the rules. I didn't discuss this with CTAC or other practitioners, but my own guess is that if it's already part of the rules, it will mean that if there's any departure or deviation from the rules, there are going to be like wider implications on the validity or enforceability of the final word. But if it still stands as a guideline which leave the discretion to the tribunal to decide whether and to extent to apply, then actually it's enhance the flexibility in the arbitration itself. As I said, it's a pretty small development, but it actually gives rise to more things we can think about in the future, whether things will change and how things will change in the future. So here I pose 3 open questions for the audience and for the institution and practitioners to think about and share their views. The first is that given that CTAC has made this change, whether other institutions like BAC itself will similarly publish their own guidelines on evidence, especially in cases where there will be multinational international parties, and whether they're going to also change their rules to make it more likely to be applied. And the second question is that, will the evidence guidelines and practice become more aligned or more diverged? And on this point, I think I recall to have some interesting discussions with some famous arbitration practitioners in the common law jurisdiction who basically said to me that he cannot imagine how to get the truth of the case without doing cross-examination. But equally, I also hear some comments from also a well-known practitioner and actually arbitrator in another common law jurisdiction saying that in his experiences, no matter whether you choose the common law way of dealing with evidence or civil law way of dealing with evidence, the substantive justice is largely the same. It's just a different rules to come to pretty similar grounds. And on that note, I would say that it seems that the general trend is that the parties in national arbitration will try to align because of the emergence of the IBA guidelines or other things, and try to learn from each other and tailor-made their evidence rules in an evidence practice. But whether there will be, this necessarily means that the common law style, which is very influential in nowadays international arbitration, is really the best practice, or it's just a good practice for certain type of cases, and there will be things that can be learned from the civil law practice. And of course, that's also part of my last open question, which is that to what extent the common law style evidence rules will be adopted in Chinese arbitration. And on this, we know that even in arbitration seated in Hong Kong or Singapore, or New York, or London, and even in cases where the rules or the evidence guidelines provides that there should be some discovery, witness statement, etc. The extent of those discovery, witness cross-examination, etc. is still vary a lot, right? So if you have a tribunal which is presided by a US litigator or US former judge, you probably expect to have a very expensive discovery. But if you have more civil law background arbitrator or more full-time professional arbitrator, which has less court experiences, then the discovery will be more limited. So there will still be things that the parties or counsels can do, even under the same rules, to tailor-make their strategy to suit their objective and the specifics of their case. That concludes my, my presentation, and also welcome views from others. Thank you.
Thank you, Sheila. Thank you, Sheila, for sharing your observation on the CTAC's evidence rules. We know Professor Lu is the main drafter for his evidence rules. No, I'm not. I don't blame anyone, but I know these rules become published in 2015. But during the last 9 years, I don't know how many CTAC cases had actually adopted this evidentiary rules. I think this is a game changer, you know. So I'm very interested to know Professor Lu's observation on this new revisions of the CTAC rules, allowing the tribunal to use these rules on its own discretion. Thank you, Professor Lu.
Okay, thank you, Helen. Actually, Helen has complained about the failure of the application of this because the previous version of the CTAC evidence guideline was too restrictive because it only allowed its application based upon the agreement of the parties. Now you know that the amended version, which came into effect at the beginning of this year, says the tribunal can also decide on its own motion. Also, Mr. Sheila has mentioned the amended CTAC arbitration rules, Article 41, has also empowered the tribunal to make that decision on its own initiative. So at the beginning, why this guideline was drafted and issued is because we see there is a great difference between the arbitration practice of the Chinese arbitration and international commercial arbitration. And also the second reason is that there is only a few legislative provisions in the arbitration laws, about 4 or 5 of them, talking about the issue of evidence. So that leaves also a vacuum for the practitioners to, in their practice of arbitration. So the original thought is to try to establish a bridge between the international practice and the Chinese practice, and of course combine those two practices and try to fill in some gaps left by the legislation. The biggest change of the amended version is to allow the tribunal to make a decision on its own initiative to apply the guidelines. Of course, you know, arbitrators are different. There are, on the roster of CTAC arbitrators, there are 1,800 plus arbitrators. So each arbitrator has different education, background, practice, experience. So they may feel it comfortable or uncomfortable to practice IBA rules, or some of them are the retired Chinese judges. They are so familiar with the court evidence rules. You know, the Chinese arbitration practice have been heavily impacted by the Chinese judicial practice. The newly amended the Supreme Court evidence rules, there's a difference. I think the new rules has some changes. I will mention later, maybe on the burden on the standard of proof. So you can see the difference. So I think the guideline will provide some help, assistance to both the Chinese counsel and international lawyers. For instance, for international lawyers, you may find it familiar to see there is document production. There are cross-examination of witness of facts and experts. But also, the guideline draw your attention to a special Chinese practice that all the documents has to be presented during the hearing, and the parties has the right to question those the genuinity or truthfulness and the relevance and also other aspects of the documents. So that brings your attention to those practices. So the foreign counsel may find it some familiar and some will be unfamiliar, but they can, if they apply the evidence guideline, they will feel more comfortable than before. But for Chinese lawyers, there are also some because as Mr. Sheila has mentioned, the CETA guideline has, especially on issues of document production and examination of witnesses and experts, which has learned a lot from the IBA rules. So some of the Chinese arbitration practitioners may not be that familiar. So they can, by applying the guideline, the CETA guidelines, they may be gradually adapted to this practice. Lastly, as I mentioned, there are still differences. I read the new Chinese courts, Supreme Court's rules on the evidence on civil cases. Previously, you know, the Chinese court, Chinese judicial practice has put a very heavy burden on the plaintiff. So what they say, the burden, the standard of proof is what in Chinese is 高度盖然性, maybe in English is higher probability. Now the new rules, they delete that expression, I think, but they use beyond any doubt, which is very, very heavy burden.
Yeah.
You know, in international arbitration practice, the burden is a balance of probability or the preponderance of evidence. So that rules has been introduced in the CETA guidelines. Of course, there are some exceptions because if the fraudulent, you allege fraud or similar matters of seriousness, and the burden will be higher, burden will be heavier, and I mean the standard will be higher. But still, the tribunal has its discretion. I hope they will use this as assistance and guidelines to direct their future arbitration practice.
Thank you. Thank you, Professor Lu, for sharing your insight. Let's move to the next topic because we have very limited time. Mr. Wang Zhengzhi will give us an introduction on the update on the role of arbitration in settling IP disputes. Mr. Wang, thank you.
Thank you, Helen. Good morning. Yes, it's morning. Good morning, everyone. Very happy to be here. As you have found, my co-panelists, professors, lawyers are talking about legislation, regulation, policy, about arbitration. I think that's academic things, heavy topics. Let me try to share you with an easy topic. What's happening about IP disputes, whether we can, arbitrate IP disputes in arbitration. You may notice the recent one of the hot topic in recent years, whether IP infringements can be arbitrated. People are discussing how to reach agreement for the alleged infringers and IP rights holders. Is that possible? How can that be possible between such parties? In reality, we all know the IP disputes, the case number are rising every year. We can see the numbers every World IP Day, April 26th, the number increasing, such as disputes over trademark registration, patent granting, patent prosecution, patent validity. Can these disputes be arbitrated? On one hand, we notice there are legislations, mostly outside China, like Singapore, United States, and Hong Kong. There are legislations already. They say, well, whatever the dispute is, I mean, IP dispute is, all of these can be arbitrated. On the other hand, in China, inside China, we are still debating. We argue about for example, the validity of patent disputes. Can these kind of disputes really be arbitrated? Let me share some numbers with you. These 60, almost 70 arbitration committees, mostly Chinese institutions, they all set up their own IP, what they call centers or institutes within the committee. Over the past few years, there are almost 3,000 cases handled by these almost 70 arbitration committees. There are also big total amount of dispute money involved. This number about CTAC, we talked about CTAC this morning too. About 15% of disputes received at CTAC is IP disputes. This number is not small. About 15%, and these 15% IP disputes involving IP, the case number is 400. The dispute amount of money almost 20 billion yuan over the past 5 years. For those people or practitioners, they are in favor of arbitrating IP disputes. They found many strong points about the mechanism about arbitration, like efficiency, flexibility, confidentiality, etc. I'm not going to go through all these strong points since we don't have enough time. Helen asked me say a few words about this report. This is the annual report published by CTAC. We did this in the last 2 years. You can easily find this publication if you are interested. We organize a group of lawyers, professors, of course. Mostly they are arbitrators too. We are working together. We get these 2 annual reports published already. If you are interested, you can also see our chapters, our highlights of the report. I'm going to give the quick review about these highlights of these 2 annual reports. We do study, of course, combining some serious and actual cases together. We want to compare, do some comparison. Also, we invite some international lawyers and arbitrators working with us. We want to have the global perspective to review, to check with some arbitration IP cases outside China too. In chapters 3 and 4, I believe, we discuss the we focus on the discussion about the arbitrability, which is the biggest area, biggest topic for those who are interested in IP dispute arbitrating by arbitrating in the institutions. Of course, at the last chapter, we also provide some IP arbitration cases according to the industries like digital assets, internet, etc. From the practice and the actual experience for myself, I feel the arbitration is important mean or a channel to settling disputes, even for those like patent validity cases or like patent registration cases. Of course, this is a still new topic for some academics. They think this is still a long way to go. Here, I just share this maybe a small part compared with the whole arbitration fields, but it's on the way, it's going. Okay, that concludes my presentation. Thank you.
Thank you. Thank you. Thank you, Mr. Wang. I invite Sheila to give comments because as a practitioner, we do notice the increasing number of the arbitration proceeding in IP area. For example, SEP, licensing fee, global arrangement, something like that, and the parallel proceeding, arbitration and litigation proceeding in parallel.
Sure. Thanks, Helen. Thanks, Ms. Wang. I'll keep it very briefly. I think this is an area where it's most interesting in the sense that there will going to be a lot of planning and sort of foreign shopping at the beginning of the case. Because for many cases, actually, this has been briefly discussed in the event on Monday with BIAF, where there could be cases, there's an arbitration clause in agreement, for example, for some trade secret license agreement. And then there could be also like affiliate party of the party to the contract violate that trade secret. Then the licensor party will need to think about whether they want to pursue the case in arbitration or pursue the case against the third party who is affiliate of the counterparty directly at court. And there could also be other cases where, for example, on the validity of the patents or other IP, whether you want to do the case first in arbitration or you want to bring the case in national court for some strategic reasons. And that also will give rise to some interesting question of like when there are parallel and competing proceedings, whether you can get like anti-suit injunction, whether at the later stage you can try to set aside for lack of arbitrability or if there's like conflicting decisions of the court and the arbitral tribunal, where that's the ground for rejection, denial of enforcement on the basis of public policy. So I think more questions than any comments or answers, but I just feel that's a very interesting area which is still developing.
Thank you. Considering the large number of the arbitration cases managed by Chinese arbitration institutions, we do see many new developments, but we are only have 1.5 hours for today's discussion. Thank you very much for my dear panel speakers for sharing your experience. I benefited a lot and hope the audience also benefited from their practical experience. We look forward to the next event for us to further develop this topic. Thank you very much. Thank you.
Yeah, so thank you. While they take the picture, we'll have a small coffee break. So please feel free to grab some coffee and something to eat, and we'll see you back at 11:30 for the next panel. Thank you.